this morning's docket. That is case number 105603, State of Kansas v. Mong Swady.
May it please the Court, the appellee, State of Kansas, appears by Stephen Obermeyer. Mr. Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. Having heard the previous arguments in State v. Edwards, I would like to basically try and discuss 3 different points. The first is the language of the robbery and aggravated robbery statute. The second is the Montgomery decision. And the third case is State v. Long, which discusses a lesser included offense. With regard to the first argument, the robbery statute is unambiguous and plain, and so there's not a need to speculate as to what it means, and there's not a need to add elements to it, such as the Court of Appeals did in this case. As you know, either as lawyers trying civil or criminal cases, or as trial judges, you rely on the language of the statute as far as what the elements are. You rely on the pattern instructions as far as what proof has to be presented. And the legislature knows how to use the language, facilitate the commission of a crime. It's in the kidnapping statute. And that's what I thought there was a reference to in State v. Montgomery. So the legislature did not put in facilitate the commission of another crime in the aggravated robbery statute. And I would ask the court not to apply a State v. Buggs, which is the leading case on kidnapping and takings, to facilitate the commission of a crime to robbery cases. Please don't extrapolate that to robbery cases. As the court knows, all crimes are defined by statute. All lesser included offenses are also defined by statute, and there's 4 ways to have that. You can have a lesser degree of the same crime. You can have lesser crimes that are identical, they have all the elements identical, and then you can have an attempt to have one of those 2 options. And I think in State v. Montgomery, where the court had difficulty was with the issue that, well, how can theft be a specific intent crime versus robbery being a general intent crime? So we have this addition of the facilitating the commission of language. And I think my answer to this incongruity perceived by the court in Montgomery is that Montgomery applied the same elements analysis, which is one of the 4 ways to get to a lesser offense. Montgomery did not apply the lesser degree of the same crime analysis. And usually when you think of a lesser degree of the same crime, you have second degree as a lesser degree of first degree. They both have degree in it, so that's pretty easy. And that also extends to voluntary manslaughter and involuntary manslaughter. Aggravated burglary and burglary, are those lesser degrees of the same crime, or are those lessers because all elements of the lesser crime are identical? I'm not sure about that, but I am sure that the Montgomery court was just looking at all elements being identical, and that was why it perceived an intent to keep or to permanently deprive as an element. And I guess I would comment, in your typical carjacking case, give me your car. Is the carjacker intending to keep the car to permanently deprive? No, they just want to take it by force to get away.
I see the real issue here is whether there was an intent to take the car. The guy rolled out.
Correct.
He relinquished the car. The guy wasn't trying to take.
Correct.
And then he got behind the wheel and drove it back to where the victim was. And he used it for a means of conveyance to get back to the victim to get money. And so don't you, even if it's general intent, doesn't he have to intend to take the car rather than just accept relinquishment? You follow what I'm saying?
Yes, I think I follow what you're saying. And for the benefits of the students, basically this guy went on an online date looking for love in all the wrong places. He leaves the date, somebody gets in his car unbeknownst to him, in the back seat, and they jump out when he's gone about 20 miles and put a knife around his throat. And so that person is able to get out of the car when it slows down enough and bails. Okay. Then the defendant who's in the back seat gets in the front seat. As Judge Welch, the trial judge, said, he could have just fled on foot at that point. Or what if the police showed up right at that point? Would that not be a taking or an attempted taking, because the jury was instructed on attempted aggravated robbery? When the police show up, we have to wait and see how far he's going to drive or where he's going to go with it before we can say that he's committed that. So I think, and that's what the trial judge said, once he got out of the back seat and in the front seat, puts the car in gear and drives back to pursue the victim.
And to clarify, he drove back, got out of the car, and he was trying to physically take stuff off, or money or whatever, property off of the victim, personally.
Correct.
And so he drove the car back, jumped out, and continued his efforts to steal property from the person. And what I'm saying is, how can you infer an intent to take the car when he simply accepted abandonment, then drove it back to where the victim was? I think you still have to have that intent to take the car.
And he did not get back in the car after that. So
Right.
he fled on foot. But I think if you look at it through the lens of sufficiency of the evidence as opposed to a question of law, could a rational fact finder find that he took the car when he got out of the back seat to the front seat, and he had done that by force? And the jury found that he did.
Where was the force in the taking the car?
Well, there'd been the knife around the throat, and
Because the
threat.
force he was using to try to rob the person was what facilitated the abandonment, and so you could transfer that force to the taking that doesn't appear was intended.
Well, he did not say, I'm going to take the car also. But I know there's a case, I don't know, it's in the briefs, where the victim is killed and the defendant comes back later and takes property. And that was still forceful taking at that point. But certainly the defendant had options. He could have just fled on foot at that point instead of taking the Durango by getting in the driver's seat and backing it up to pursue the victim.
So you're agreeing that it was not a taking of the vehicle until he moved into the driver's seat?
Correct.
Okay.
If he would have just left out of the back seat, that would not have been an aggravated robbery of the vehicle. But when he exercised that control over it by getting from the back seat into the front seat and putting it in reverse, then he did do that. So that's my take on Montgomery, that the court was just confusing all elements of the lesser crime. You don't need that to have a lesser degree of the same crime. That a lesser included crime can be a lesser degree without an identity of elements. The other case I wanted to discuss is the State versus Long, which is a mid-1980s case that looks at whether or not theft is a lesser of robbery under the statute, under the 213107. And the court says, well, we don't have an identity of elements, so it's not that. But the court goes ahead and says that it is a lesser degree of the same crime under the first option. And the court goes to the analysis that, and this is really, the court doesn't do that a lot these days, but the court looks at what the common law was, what the legislative intent was, and decided that it was a lesser degree of the same crime. And the court cited Wharton's criminal law. So now I'm going to have to start looking at Wharton's criminal law to see whether the common law said that a crime's a lesser degree of an offense, and whether commentators, well, the Long Court said one commentator advocates the use of the legislative intent test in determining whether an offense is charged or multiplicitous or whether one is included in another, and then it concludes that it is a lesser crime. But it's a little bit more difficult analysis, I think, than just the straight elements. Do you have the same elements? Because I don't think that temporary deprivation is a lesser of theft, and I don't know how you can reconcile that with robbery and theft. But I think most people think identity of elements makes it simple, or a lesser degree of the same crime. And again, I know first degree, second degree are lesser degrees, but the court in Long said that theft is a lesser degree under the first option of the statute.
In fact, last Friday, didn't we go through the lesser degree in Ramirez?
I believe you did, and it was kind of the same analysis as far as the common law. We're looking at Wharton's and then saying it's a lesser degree, which is different from the identity of elements. So that's where I think the Montgomery Court got it wrong. And even if Long is right, it's still a different analysis under the statute that defines lesser included offenses.
Briefly, you were here for the
Yes,
State v.
I
Edwards
was.
argument. Our concern regarding the breadth, if we disavow Montgomery in terms of the incidental taking.
Yes.
Care to comment on that? Or
Just a couple of comments on State versus Button Snatcher. I think it would be, one issue would be whether criminal damage to property would be a more specific offense anyway. But I think you could look at KSA 215202, which defines culpable mental states and intentionally. And it says a person acts intentionally with respect to the nature of the person's conduct when it is such person's conscious objective or desire to engage in the conduct or cause the result. So I think that might make a difference in some of the hypotheticals. And then the other thing from Chief Justice Ness's question, well, if you're the legislature, how would you amend the statute? That tells me that it's something the legislature has to do. I mean, the court interprets the statute and applies it, and the statute says take by threat, which is what we have in this case, and force. But as far as charging that type of case, I'm not sure if it would happen. But you do have the 215202 and whether criminal damage is more specific. And what trial judge would not grant a departure, dispositional or durational, in that scenario? I mean, I would think would be some of my answers to that question.
I'm not so sure that definition fully supports you, cause the result was part of that, of intentional, and here the result was sort of serendipitous that the person abandoned the car. He didn't intend for the person to leave the car, and he gained possession of it.
Well, the car was abandoned, and then the defendant could have fled the car, but
if he gets into the driver's seat to drive back to complete his crime of personal robbery, why did he intend to cause the result of taking the car when he had no intention of taking the car?
Well, in that case, I think he's took the property
He took control over the property after it was
Right.
abandoned to him, but
Right.
he didn't really take the car.
I guess I'm not seeing the difference.
He actually took it back to the owner.
Like he's trying to return it to him.
Yeah, exactly. It's like, here's your car, but give me your money. And that was really pretty much the size of it.
maybe.
It's just peculiar.
Right,
Obviously,
and then
there's
further adding to the peculiarity is then why is that not an attempted aggravated robbery, which the jury had the option with, and which the Court of Appeals didn't consider. But after he got out of the car, it's still in reverse, and it goes another 700 feet on I-35, backwards. So maybe he couldn't have fled on foot because he didn't put it in park. But at any rate, those are my best answers off the cuff to some of those questions, and thank you for your time.
Do we have any further questions of counsel? Thank you, counsel. Before you begin your presentation, we have a group of students coming in. I'd like to take a moment and find out who they are.
Of course, Your Honor.
And while you may remain here, and to help them out, I know Mr. Obermeyer already gave everybody else the facts of the case, but when you start, if it doesn't disrupt the flow of your narrative, if you could spend maybe 60 seconds explaining what this case is about for their benefit, that'd be great.
I'd be happy to.
All right, thank you. We had a number of young people come in. Could someone responsible for them stand up and tell us who they are?
We are from Elslane Elementary, 5th grade.
The Cardinals?
Yes. By Salina.
Exactly. Well, Justice Rosen always has his old high school come in, and they lead a cheer for him. But the Elsaline is about as close as I've gotten. Thank you for coming. Please proceed.
Good morning, Your Honors. May it please the Court. Lydia Krebs of the Kansas Appellate Defender Office for the appellant, Mr. Swady. And just in view of a brief recitation of the facts, the Court of Appeals began its opinion in this case by saying that it illustrated one of the more bizarre perils of online dating. It appears that the victim in this case had been communicating online with Ms. Harris for some time, and they had agreed to meet in person. Ms. Harris, during this interaction, was on the telephone texting and went to the bathroom and apparently made some phone calls there. And the two agreed to then meet up later in the day after eating a meal together. The victim in this case, Mr. Price, went to a Walmart store, did a little shopping, and then waited there for her in his Dodge Durango. When Ms. Harris arrived, she parked her car in such a way that if he climbed into her car, he would have had his back to his Dodge Durango as he faced her in order to converse. While they're conversing, apparently Mr. Swady comes and sneaks into the Dodge Durango into the back seat, and then as Mr. Price is driving that vehicle, he reaches around with a knife, demands his money. Rather than giving him his money, Price jumps out of the moving vehicle. The car continues down the highway, hits a Jersey barrier. Then Mr. Swady climbs into the front seat, reverses 30 to 40 feet back to where the victim is standing, gets out of the car, and again demands his money. When that is unsuccessful, again, he flees up an embankment. So, in light of those facts, I would like to briefly address some confusion that the state expressed as far as attempted aggravated robbery and robbery. The jury here was instructed on both crimes, but they were for different acts here. The aggravated robbery was only to the Dodge Durango. That's instruction 16 on page 33. And then I believe the attempted aggravated robbery was also instructed on, but it was limited to the crime of... Well, actually, I take that back, Your Honor. It looks like on page 31, aggravated robbery of the Durango, that he may have gotten the lesser of attempted aggravated robbery on the Durango as well. So I suppose that they could have convicted on that. That also adds an extra wrinkle in this case because if this court affirms this conviction, I also made a multiplicity argument in the original brief, and the Court of Appeals didn't address that as far as the taking of the Durango and the attempted taking of the property being multiplicitous. The Court of Appeals didn't address that because it reversed the aggravated robbery conviction. So if this court affirms that conviction, I would argue it needs to be remanded to the Court of Appeals for a finding on whether those two convictions are multiplicitous, or that this court in the judicial interest of judicial economy could reach that decision.
And your argument in that regard is that he was attempting to take his money from his person, and it evolved into a situation where he had possession and control of the vehicle, and there was no fresh impulse to commit a separate. It was all part
exactly.
of
the impulse, yes.
Unitary conduct, as we would say.
Yes, exactly. And that the legislature in FAM expressed that the court in FAM expressed that the legislature hasn't defined clearly an intent to criminalize that is more than one unit of prosecution. I would also argue that the state's argument, both in this case and in the previous argument in Edwards, and the Court of Appeals opinion in Edwards, kind of go off on this red herring into this discussion about an intent to permanently deprive. I don't think that that's necessary to this case. I think that to the extent that it was addressed in Montgomery, that it was dicta. I don't think it was necessary to that case as well either. And I think the fact that the Montgomery court relied on Adam, which doesn't read that specific intent requirement into the statute either, indicates that nobody here is talking about requiring a specific intent requirement or that arguing that this court should read such a requirement into the statute. That's certainly not my argument today. I think that instead, I'm arguing both the general intent requirement that I think this court has been discussing this morning, that it has to be a general intent to take something by force. And here he intended to take certain property by force, the victim's money, but didn't intend to take the vehicle by force. Now, he applied force that resulted in the relinquishment of the vehicle, and then he intentionally took the vehicle. But I think I would argue that there has to be some, that's a unit to take something by force, and the general intent requirement applies to that entire unit.
So are you
as a whole.
basically making a sufficiency argument now, or
Well, I think
based
that's-
on that, I mean, that if general intent is, if the focus is to take something by force, then there's not sufficient evidence to conclude that from the facts of this case.
And I would say that that was the argument that Justice Johnson was making, and so I was simply saying that that's another way to reach the same result in this case, but that isn't what I argued below. I didn't argue in my brief that there had to be a unitary intent to take by force, that those two things, the intent to take by force, had to be applied as a whole. And obviously this court has held that that's not true. That's what the court said in Meyer, that you can intend to kill someone and then come back later and steal from the victim's body, and that constitutes a robbery. I would argue that that's incorrect, that certainly one interpretation of the aggravated robbery statute would be to interpret it in a way that requires the intent to take be contemporaneous with the application of the force, and that under the rule of lenity that would require a different result in Meyer. But again, I don't think that the court needs to address that in this case. Here, I think we can specifically rely on Montgomery. The state started its argument by talking a little bit about Buggs and the kidnapping statute, and it claimed to this court that what the court did in Buggs was read or interpret existing statutory language. It said that this merely incidental language or to facilitate the crime language is part of the kidnapping statute. So the kidnapping statute requires an intent to facilitate a crime. But what this court has actually read into that statute is not just an intent to facilitate the crime, but out of whole cloth that the act actually did facilitate a crime. And so I think the state is incorrect in suggesting that this court didn't read additional language into Buggs. I think that's exactly what this court did. And I think it did it in the same manner that it did in this case. In both these statutes, the kidnapping statute and the robbery statute, we have a shift from common law to the statutory law. And in both cases, in making that shift, the legislature removed some of the common law elements of the crime. For instance, in the kidnapping statute, we used to have sort of an aspiratation requirement. You had to take and move the victim to a certain point. We've taken that out, and instead, in order to interpret the statute in a reasonable way, which this court has a duty to do, this court has read additional language into the statute. Basically, the taking can't be incidental. It has to have some independent legal significance other than just the other crime that was occurring. And that's exactly what the Court of Appeals did in Montgomery in interpreting the robbery statute, which used to require this intent to permanently deprive. And the court, in interpreting the statute in Montgomery, said, well, we don't have the statutory requirement anymore, but in order to interpret this statute in a way as to avoid the absurd results that your honors have pointed out would occur if we didn't have Montgomery, we have to read this additional language into the statute that the taking can't be merely incidental to another crime. So I think this court has two avenues of affirming the Court of Appeals holding here. One of them would be to take this tack that because he didn't take the car with the intent to take the car by force, but rather applied the force, this serendipitously resulted in the abandonment of the car and then he intentionally took the car, that's not what the robbery statute contemplates when the intent to take by force are separated. So that's one avenue this court could use to affirm the Court of Appeals decision. The other would just be to affirm Montgomery. And I would argue that the fact that the legislature hasn't amended the statute since the holding of Montgomery reflects, and it has amended the robbery statute since then. During the recodification recently, it inserted a new word into the robbery statute. So it's had ample opportunity to change that statute since the holding of Montgomery. It hasn't done so, and I think that indicates that the legislature agrees with the Montgomery court's interpretation of the statute, and that it's necessary to guard against absurd results.
Any further presentation, counsel?
No, Your Honor.
Do we have any further questions? Thank you.
Thank you.
You'd reserve 3 minutes for rebuttal.
Thank you. I just have a couple of comments. If I misstated anything from Bugs, the court has the language. My point there was the statute had in it facilitating as an intent, I believe, which the Montgomery court was trying to read into the robbery statute. In Montgomery, at page 350, volume 26, Canap 2nd, the court says there is no evidence in the record that appellant removed the glasses with an intent to keep them. I'm thinking that's intent to permanently deprive. Right after the Montgomery court has discussed that it was incongruous that theft would be a misdemeanor where robbery would be a level 5 person felony. So that was where I read that element in there. But at any rate, the taking of something that's incidental to a commission of another crime is not in the statute, and just looking at the issue as a sufficiency issue, could a rational fact finder have found the defendant guilty beyond a reasonable doubt? I submit the answer to that question is yes, and counsel is correct. If you did reverse, then it would have to be remanded to the Court of Appeals to address the multiplicity issue, which it did not address.
And this is just a curiosity question. In the initial trial, was there an attempted aggravated robbery based upon the trying to take the money? Or was it just solely
Yes.
the focus on the car?
That was count 3.
That was count 3. Okay,
Yes.
and was the, okay, thank you.
So there was a lesser included given for the aggravated robbery on
Of
the
the
car?
Durango. Yes.
Yeah, or on the vehicle, okay.
Yes.
And then this third count was a separate attempted aggravated robbery on the money.
Correct.
Okay, very good, thanks.
Any further questions?
Yeah, I have one more. If he'd said, "Give me your watch and your money," would that have been 2 counts of attempted aggravated robbery? You see where I'm getting
Yes.
at? If we have a robbery here and he takes his watch, takes his money, takes his car, do we have 1 robbery or do we have 3?
And that might be the multiplicity issue that wasn't addressed, I guess. But I'm thinking of, I know there's an aggravated battery case where a guy gets stabbed and has something severed, part of his body severed, and the court says that's just 1 count. I mean, you could do all the slashing you want, it's 1 count. So I guess it would be 1 count.
Well, we have a more recent case where someone off of a counter at the bar took a money bag and a purse, and we said that was 1 theft. It wasn't 2 counts.
Same victim?
Yeah.
Okay.
Well, no, it was, same victim, but
Same event.
interrelated, a restaurant business and the co-owner. But yeah, that wasn't what the case turned on, was who owned the property.
It seems like there's a theft case where there's different purses in a room and they're all taken, and I forget whether that's a 1 count or multiple counts. But in this case, I'd agree it would be 1 count for threatening to take the wallet and the
Watch.
and the watch.
Yeah.
But I don't think a fact finder is bound by what the declaration of the robber is when they take the car after that.
Well, no, because it's not a fact determination. Whether that's 1 unit of prosecution, it's not a jury question.
Correct. If we get back to whether it's one aggravated robbery.
And I guess where I was headed here is that even though it was serendipitous, the taking of the car, it was all part of one, at the same location, at the same time, whatever the four factors are, that it's unitary conduct. Why wasn't it unitary conduct that would lead to one unit of prosecution, regardless of the amount of property or character of the property taken?
Well, I think the analysis here was that when the victim left, that the attempted aggravated robbery was when he, give me your money, watch, and then the aggravated robbery was the taking of the car. I know that's issue 4, I think, in the briefs, and it did not get addressed, but.
Well, and where we are, regardless of the issues, we're into the right for the wrong reason. I mean, can't we affirm the Court of Appeals if the result was correct, even though their rationale was perhaps suspect?
Well, except you have the aggravated robbery, which is the more serious than the attempted aggravated robbery. So I think that would be the problem with that.
Any more questions of counsel? Thank you.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.